Record for State of Ohio versus Brian Jones, case number 25CR43034. Mr. Jones is present today with his attorney, Michael Brush. The state is represented by Brian Goodyear. We are here for a second pretrial on the case, and you wanted to address bond?
I do, Your Honor. So he was released last week, and there's really two kind of asks, if you will. The first one, I'll start with the one that probably is less objectionable. I think they're going to object to both, but I'll start with he's on house arrest right now, Your Honor, where he can't leave the home at all. He needs to work. He did make bond. I shouldn't say he, his family did. Now that he's out, he's able to get some of his finances. Got to pay some people back for bond. Got to pay the bills in the house. Because that's the house is still there even though he's not allowed to be in there, and there are other financial things that he needs to take care of. So he wants to try to find a temporary job. Before this incident, he was gainfully employed for 20 some odd years at Children's Hospital. So his income has stopped at this point. So he wants to try to do that. So he would just ask for a small modification for GPS. That's ask number one, Judge. And then ask number two is a little bit different. And I brought both these up to the prosecutor, so I understand where they're coming from. But right now, he's not allowed back in the home where he resides. Nobody else lives there. It's just him. It's my understanding that the last time we were here for bond, there were two issues with that. One being that there may be firearms in the home, even though the police did take, I think, several. They testified last week, or the last time we were here, they took several out. There would not, I can tell you there's no firearms in the home right now, and I would also explain to the court that anybody can go in, sheriffs, anybody that needs to go in there to observe, and he'd be willing to do that. There will be no firearms in the home whatsoever if allowed to go back to his home. Right now he's staying with his brother.
Yes.
His brother. And the other reason for that is, Your Honor, that it's obviously he's paying the bills there. I'm assuming there's a mortgage there. There's at some point was worried about the pipes freezing. I think he took care of that with somebody else who's taken care of that recently. The other issue from the state's perspective, I think, was there were several neighbors, I think, that called into the prosecutor's office originally and said, I'm worried about this guy. And that's fine. I take the state at their word that that's the phone calls they got. But on the same token, he is innocent until proven guilty. If firearms are not in the home, he certainly has a right to be in the home that he's paying for. I understand community safety at this point, but now that he is out, Your Honor, I think those two small modifications of bond are reasonable under these circumstances, and obviously he'd follow that to the T. I also believe, Your Honor, that in this discussion after talking with the prosecutor, that it's going to come up that he's not on an alcohol monitor, because even at the arraignment, even in our first discussion here, I discussed the fact that alcohol is a factor here. Nowhere, the arraignment, not here, was there anything checked for alcohol monitoring. We'll do that. That's fine. That's not a problem at all. Drugs, alcohol, it's not a problem. He just wants to try to get to work to make some money. He wants to try to get back into his own home. So that's all we have. Thank you.
Okay, thank you. Anything from the state?
Well, first, Judge, I would point out that there are two victims in this case. One is here. Deputy Savage is here. He is the deputy was present when he was threatened with a gun by the defendant. But in addition, there's a second victim who's a neighbor, and it's her house that was shot at by the defendant. Of course, defense counsel, there's been no motion filed for bond. There's been no notice to the state regarding a request that today there would be any request regarding bond. So we frankly think that the process should be that defense counsel files a motion and the court schedules his motion for a hearing so that we can provide notice to the victim to be present for that hearing. Judge, depending on your feeling about that, I don't know if you want me to go forward or if you would like to continue it for that purpose.
Were the victims notified of this hearing?
Judge, I am sure that the victim was notified there would be a pretrial today, but I'm certain that they were not notified that there could be a discussion about bond because there was nothing filed.
Okay. Well, I've said before that they should know that. They should know that if there's a hearing, bond can be addressed at any hearing. Deputy, would you like to be heard on the request? Okay. Um, the facts are pretty unique. I understand that he is presumed innocent in the case, and what a problem it is not to be able to go to your own home. I understand that. And I can see, since the allegations are that he shot from his home into the neighbor's house, that she's going to be pretty concerned too. How far away is her house from his house?
Do you know how far they were?
It's directly behind him, Your Honor.
Okay. Well, I think every time you make a decision like this, you just hope that the worst case scenario doesn't happen. But I'm going to.
Judge, I'm sorry, I didn't mean to interrupt. Can I be heard on? I
Oh,
didn't know
I'm
if you were.
sorry, I thought you were. Go ahead.
I was waiting to see if you wanted me to
Yeah,
go forward.
go
Okay.
ahead.
So, Judge, I will tell you, obviously, I know with certainty that the victim in the offense, the homeowner, is very concerned about him. We have received information from other neighbors about concerns about him. Apparently, this is not the only time he's been intoxicated like this, causing problems. According to the neighbor that I talked to, it happens. I don't know why Mr. Jones finds this very funny, but he's looking at me and smiling real big. So apparently, this is a big joke to
It
him.
may be, no, it may be just nervous.
Well, I don't know, but in any event, Judge, apparently this is a common thing for him to be intoxicated and cause problems in this neighborhood. In particular, on this occasion, Your Honor, we have obviously, number one, the homeowner whose home was struck by the bird shot that was fired from his shotgun, but also the fact that he threatened a deputy sheriff with a firearm when the sheriff was trying to simply contact him. I think that those are obviously very serious allegations. He's facing mandatory prison time if he's convicted in this case, which of course makes us all the more concerning regarding public safety. And Judge, regarding the EMHA, I don't think it's necessary for him to somehow be on open schedule or have just a curfew or GPS, whatever he's referring to by referring to just GPS. He can certainly get hours. If he has verifiable employment, he can get hours away from the residence he's living in to go to his job through EMHA. I don't think he needs to have some major change in what his bond conditions are to be able to allow him to work. I mean, there's a lot of people that do that. So, I mean, I think that if he can provide verifiable employment to community corrections, then obviously he can get hours out to do that. I do agree, Judge, with counsel that regardless of what the court does, he should also be on alcohol monitor because he clearly alcohol was a motivating factor in this offense. He was apparently quite intoxicated when all this took place, so an alcohol monitor would make sense to add that. But I don't see, number one, apparently he's been able to be released from jail at a residence that he has the ability to be on the EMHA. And I think with the concerns of what took place and the victims and the other neighbors, I think it's appropriate for him to not live in that home. And then I think that he can, whatever concerns he has about employment can be addressed through the EMHA he's already on. So we would ask the court not to modify the bond.
Okay, thank you. Mr. Brush, what is the, well, you're saying he needs to take care of his house, right?
Yes, sir.
He has a place with his brother.
He does. He's staying there now. And Your Honor, I think part of the reason for wanting GPS is that he wants to go apply for jobs. I will say that going back to the house issue now, this incident, the house got kind of destroyed. Tear gas went through, a lot of things that I'm not even going to be able to speak to fully were destroyed in that house. He wants to fix those things up. This may be a situation where he moves out of that neighborhood altogether, especially now now he knows what he is hearing from all of his neighbors. But the house is in complete disarray and a mess, and he wants to be able to work on that. He wants to be able to fix the things that he can fix. And as far as a work schedule, we're not asking for a carte blanche, hey, you can go out 8 to 5. I would suspect that he would have verifiable job applications that he could go, that he would go apply for a job, and then if he got that job, that he could provide hours to the court. This isn't a situation where he's trying to to get out and go. He legitimately is in financial issue, has significant financial issues right now, wants to attempt to work, understands the gravity of this. And for what it's worth, I've met this guy 2 or 3 times in the darkest times of his life, and he was smiling at me. It's I don't know if it's nerves or what it is. It's unusual. I've noticed it from the beginning, but I can speak for him, and I don't believe, Mr. Prosecutor, that he meant any disrespect by having a smile on his face. He takes this very seriously, Your Honor.
Okay. I see an OVI in 20 years ago, 19, it'll be 20 years in January, and that's all I see as far as criminal record. Do you have anything in addition to that?
As far as his criminal record, Judge?
Yes.
I think that beyond just his criminal history, what I'm trying to press the court on too is that it seems pretty clear that alcohol was a substantial issue in this case, and according to the information from the neighbors, it has been a substantial issue of his for a period of time, because this has been an ongoing problem apparently in the neighborhood.
Okay. My point is, I understand that people who have an alcohol disorder, use disorder, substance use disorder, it's not easy to stop. And if he does something, he's really facing a lot of time if he's convicted of these charges. So I'm keeping that in mind and hoping he understands that. I will place him on an alcohol monitor or a GPS with, see, alcohol monitor, he's already on a GPS, right? He's not on anything.
He's on EMHA right now, Judge.
He is?
Yes, sir.
Okay, so that's a GPS. He's on electronically monitored house arrest. So I'll modify that to permit him to seek work, to go to work if he gets a job, and to go to treatment and to AA meetings, NA meetings or similar meetings, group support meetings. That's not going to take place until the victim's advocate has had adequate time to notify the victim in this case. And is she here?
Judge, I don't believe she is.
Okay,
but
so,
I can. She's here. She's at work. I can speak.
okay,
With her.
so let's say 48 hours. This change will not take place for 48 hours. That way everybody's on notice. I'm not saying there's going to be a problem. I don't expect there is, but you know, these are serious charges and we have to treat them seriously. Anything else from the state?
Judge, just to clarify, I think you're saying this, but just to clarify, so the request to reside in his home is denied, but you are amending his EMHA?
No, I didn't mention it, but he is permitted to go back to his home.
Okay. Sorry. Judge, the additional, actually, Ms. Hyatt brings up a good point. Part of the issue with EMHA is that there are certain zones he's not permitted to enter because there are victims in that area. So if he were to live in his home, he would be residing in the area he's not supposed to be in.
We'll have to modify that, and that is he can't be on their property. I'll send an email. The whole point here is to let him go to his home, not drink alcohol, not possess firearms, and follow the rules of supervision, and be allowed to go to work and treatment. So, and group support meetings, which I consider a part of treatment. So I'll send that to him and let them know. Anything else, Mr. Goodyear?
No, Your Honor.
Anything else, Mr.
Judge,
Bush?
I just want to make it clear for him. I think I know the answer, but any job opportunities he has, treatment that he has, he's gonna have to provide proof of that to the electrical monitoring people before he can.
Yeah,
do it.
they'll
Right.
explain all those rules to him.
Perfect.
He
Okay.
needs to go back down there and check in
Yeah.
anyway.
And then, Judge, we'll just come back there and get a date for the next pretrial?
Yes.
Okay, thank you very much.
All right, thank you.
Nothing further.
They are breaking overnight, and here at the alert desk, a person is in custody following a SWAT standoff in Warren County. According to Warren County Sheriff's deputies, a neighbor on Post Rail Lane in Franklin Township actually called 911 to report some gunshots. That neighbor told dispatchers she heard a man yelling incoherently. The sheriff's office says when the first deputy got there, a man inside pointed a shotgun out of the home's window, racked it, and said, quote, "I've got something for you." The SWAT team was then called in. We're told they breached the front door and then used some gas to get that man out of the house. We're told that suspect has since been identified as 53-year-old Brian K. Jones and has been booked into the Warren County Jail. Right now, he's facing charges of aggravated menacing, inducing panic, and felony vandalism.